Good afternoon, everyone, and welcome to the McLaughlin College Lunchtime Talks with a very special guest, Michael Bryant. And we always begin our lunchtime talks with the land acknowledgement. This meeting is virtual, and because of that, we are not all actually gathered in the same space. York's land acknowledgement might not represent the territory that you are currently on. And I would ask, if that is the case, that you each take the responsibility to acknowledge the traditional territory that you are on and its current treaty holders. As a member of the York University community, I recognize that many Indigenous nations have long-standing relationships with the territories upon which York University campuses are located that precede the establishment of York University. York University acknowledges its presence on the traditional territory of many Indigenous nations. The area known as Tookarondo has been caretaken by the Anishinaabe Nation, the Haudenosaunee Confederacy, the Huron-Wendat, and the Métis. It is now home to many Indigenous peoples. We acknowledge the current treaty holders, the Mississaugas of the Credit First Nation. This territory is subject to the Dish with One Spoon Wampum Belt Covenant, an agreement to peaceably share and care for the Great Lakes region. Today's lunchtime talk is going to be looking at emergency management and civil liberties. And our special guest is Michael Bryant, who is the Executive Director and General Counsel of the Canadian Civil Liberties Association, probably the best well-known organization, human rights organization here in Canada. He's a member of the Law Society of Ontario, and he's also served as the Ontario Attorney General. He is a former clerk of the Chief Justice of Canada, and he's been a lecturer of law at King's College London, an adjunct professor both at the University of Toronto and Osgoode Hall. And we're very proud of the fact that he's a graduate of Osgoode Hall. He also holds an LLM from Harvard. So please join me in welcoming Michael Bryant. Michael.
Thank you very much. Thank you for asking me. I'm honored. I'm really looking forward to this. If you can stand it and you can turn your camera on, it's a way better experience for me. If you can't stand it and you've got to do the dishes at the same time, that's tough luck for me. So thank you. Let me get going. Let me see, why is this not working? This one, okay. Canadian Civil Liberties Association has been around since the 1960s. During the War Measures Act, the October crisis in 1972, were the only organization that opposed Trudeau Sr.'s use of the War Measures Act. That eventually led to CCLA, that's the acronym for my organization, being involved in the drafting of the federal emergency management legislation. And it was around that time that the federal government and the provinces came to see that the natural place for emergency management was with the provinces. And that became underscored during the SARS epidemic because it was two provinces, primarily Ontario and BC, and there was a commission that was done afterwards, led by Archie Campbell, former Chief Justice of the Superior Court. And although Campbell didn't talk about whether or not the province or the federal government should be involved, it was clear that he thought that in the case of SARS, it made sense that the provinces were involved because they are responsible for healthcare. This is important because our pandemic is being managed. If you didn't notice, it's being managed by the provinces and territories. Anyways, back to CCLA. CCLA, our mandate is to change the law. The executive director for CCLA was Alan Borovoy. He probably would have spoken at a talk like this years ago, and he would have done it, and he did it for over 40 years. The Canadian Civil Liberties Association primarily makes its changes through the courts, notwithstanding what I said about the Emergency Management Act and its changes. So, for example, in 2018, we brought a challenge to the sex education curriculum in Ontario and didn't succeed in that, although the law changed. So we're going to claim victory. We right now have matters before the courts in Ontario, in Quebec, in Newfoundland, and Alberta, challenging a myriad of different rights. Please go up onto our website, ccla.org. It was revamped earlier this year, and we provide live updates every day, sometimes more than once a day. Certainly every week, new content is put up under these various buckets of privacy, mobility rights, defending the vulnerable, policing, and so on. It's all up there on ccla.org. So if there is an issue that hit the news wires and you're thinking, I think that's a rights issue, that affects how I get around, that affects my freedom, that affects my liberty, can they do that? Go up onto ccla.org and we probably will have some content up there that will help you think through that question. We put out a report in the spring. It's currently being updated. It will be released either in December or in January. The report tried to cover what happened to Canadian rights during COVID. It was an interim report in the spring. It will be a more fulsome report involving both the first wave and the second wave, and it has categories such as what you're seeing on your screen there. We put out another report. It was called Stay Off the Grass, also early summer. It was about law enforcement in Canada and how law enforcement created a tale of two countries. There was basically Western Canada and then the rest of the country. The Northern Territories, Central and Eastern Canada all took an approach where they tried to, I would argue, ticket their way through the pandemic. And they violated the principle that a pandemic is a public health crisis, not a public order crisis. Second wave issues include the use of surveillance tech in work, at the workplace. We're seeing that already in the city of Toronto and the province of Ontario, but not the federal government workplaces. There's in fact an effort to track the workers. This could lead to or is causing what I'm going to call a category error, where the government is trying to track the disease. That's the purpose of what they're doing with the app. But instead, what they're doing is tracking the possibly diseased. We'll get into that in a minute. Second wave issues obviously include socioeconomic rights, housing in particular, and mobility rights. I don't know if I'll have much time to talk about mobility rights, but to my mind, that's the issue that has been a bit of a sleeper issue, and but I'm expecting that it's going to have massive implications on our country. And then we're going to have to, when the vaccines come out, there's going to be concern around that. Although there need not be as much fear, I think, as everybody thinks, for reasons I'll get into in a minute. We have a rule of law problem during COVID that I want to highlight now that I've given you a picture of CCLA and a picture of what we've been doing. The rule of law problem during COVID can be found in one of our Constitution Acts. The Constitution Act 1982 is contained within the Constitution Act 1982 is the Charter of Rights and Freedoms, and it starts out with a preamble saying, whereas Canada is founded upon principles that recognize the supremacy of God and the rule of law. And the rule of law. What is the rule of law? Get into that. And then it's underscored in section 1 of the Charter. Important section. How do you know? Because it's the first section, section 1. Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it. So that's the provision that means that no matter what's going on in Canada, There is never a suspension of our rights and freedoms, subject to Section 33 of the Constitution in some cases, but we'll get into that later on. Nobody is invoking Section 33 of the Charter during COVID. That's the part that is unlimited, that we have these rights and freedoms guaranteed. So the right to liberty, the right to equality, the right to freedom. Governments cannot limit our ability to get around, subject to reasonable limits prescribed by law. And that's the main part I want to emphasize: prescribed by law. The government can only limit your rights if there's a few things they've done. If it's reasonable, if it's demonstrably justified, which means there's evidence justifying what they're doing, and it's prescribed by law. The rule of law problem is with respect to the legal prescriptions to which I refer. What's a law in Canada? Obviously, legislation, the Constitution. What other laws? Regulations, Governor General order and councils, federal, territorial orders and council, territorial governments, provincial orders and council, sometimes called regulations. What are these things? I'll tell you what they are. It's like the one that's up on your screen right now. It says order and council at the top. It sets out a preamble. Then there's a bunch of sections in it saying what the rules are. So there's a couple of rules there. And then it's signed. It's recommended by a cabinet minister. In this case, it's me. I'm the cabinet minister recommending it. I sign it. The chair of cabinet signs it. The lieutenant governor signs it. And only then is it the law. These order and councils are pursuant to a statute or legislation. In this case, this one's pursuant to the Public Inquiries Act. There must be a statute or legislation that is the foundation of the order and council. You can't just make one up out of thin air. It needs to be grounded in a statute. Besides the recommender who signs it, the chair of cabinet who signs it, and the lieutenant governor, each province and the federal government have different rules as to how many people need to agree to it before it is signed by the chair of cabinet. Many of these are done in cabinet meetings. And so the cabinet agrees to it. There isn't a vote. There's just a consensus. And then they go on to the next item. When that happens, the chair of cabinet signs it. You've got the full cabinet there. What if there's just me and the chair of cabinet? I think in this case, it was Jerry Phillips. Not enough. You needed 5 cabinet ministers to sign a document for an order in council to be passed. Only 5. It's called a walk around, where they walk around with something in some cases that they don't want to put to the full cabinet. But anyways, that's the law. They're allowed to do that. 5 people have signed it. And only once the lieutenant governor has signed the order in council is it a law. The rule of law problem that we have in Canada right now during COVID is that we are being governed less by laws, it seems, and too much by podiums. I'm going to say it again. We're being governed not enough by laws, which is what the Constitution requires, remember? But we're being governed by podiums. And by that, I mean first ministers or a health minister or a chief medical officer is saying, you need to wear a mask when you go out, as an example. Or you should not gather in groups of more than 6 people. And what I want to know at the Canadian Civil Liberties Association is that person using their political authority to try and play God? Is that person pretending that their words are the law, or are they articulating what the law is? Has a law been passed that we need to know about? For example, requiring that people wear masks in public places indoors, which happened through a bylaw, a municipal bylaw. But there was a period of time there where we were, in essence, being asked to. It was being encouraged. There was advocacy at the podium. And then we would hear that we actually had to do it. And then we eventually find out about a week sometimes after the order in council is passed that it is the law, for example, of Ontario or the law of Toronto or the law of Canada. The orders in council, the changes to rules are so volatile. They're taking place so that changes are happening so quickly compared to how it normally works. Think about when cannabis was legalized, the lead up to it. You know, we had a party run for office, Liberal Party, saying we're going to legalize it. Then there was consultations, and then there was settling as to what the law is, and then there was legislation that was passed and debate around that. And then the law was going to come into effect on a particular date that was forecast and then changed and moved ahead. And there was public education campaigns and commercials that were running because people needed to learn what the law was. The law was passed, but it wouldn't go into effect until the democratically elected government felt that people had been educated. Not so with COVID. First Minister shows up at a podium, says something, as if it were the law, but in many cases, it's not the law. And in some cases, it's a little different than the law itself says. This is the rule of law problem that we have in Canada. Next, I'm going to illustrate it in part through reference to our privacy laws. For me, privacy is more about dignity and freedom than it is about the notion of privacy that sometimes causes people to question the value of it in the first place. I know some people say, for example, if you've got nothing to hide, then what do you need a privacy right for? That second guesses the value of privacy in and of itself. And so I'm saying, think of privacy less maybe in those terms about keeping secrets and more in terms of dignity and freedom. So the freedom to be a face in the crowd, the freedom to not reveal personal information about yourself to the public, the freedom not to be followed. I don't know if you've ever had that experience where you feel like you're being followed and you're full of fear. If in fact you are being followed in a mall, for example, say a Cadillac Fairview mall, where your facial fingerprint is being taken by them, it's I would argue it's your dignity that's being violated. It's as if someone's come up and taken a fingerprint off of your thumb, and it's not a violent infringement or limitation of your dignity, but it's close to that. To have someone take your fingerprint without you even knowing that they've done it, it's like they've taken a sample of yourself from you, and it violates your dignity. So you can say, well, what's the big deal if I don't have any secrets? What the big deal is the state with all this power is taking something from you. And they're, in this case, I'm saying they're taking your freedom or your dignity. Pandemic surveillance makes sense during COVID. There's an effort to try and track what? That's the question. When it comes to surveillance during the pandemic, what are we tracking? What are we surveilling? What are we following? And this causes me to dip into the ranks of philosophers, not qualified. I'm not qualified to do that, but I'm going to take a shot at it. And in particular, I believe that an error is taking place within the rule of law problem and within privacy that amounts to a category error. And these category errors can be found throughout emergency management of COVID. What's a category error? It's a mistake in which something is said or believed to be in one category or group, when in fact it belongs to another category. I heard it said recently after the planet Pluto was declared not a planet. Do you remember that? Some people said, no, that's a category error. Pluto is a planet. You're defining planet wrong. It is a planet. Well, it's true. It would be a category error if, in fact, instead of comparing apples to apples, you were comparing apples to oranges. So let me talk about the category errors that take place. And I'll give you an example right near the beginning of COVID that happened that I participated in. March 24, 2020, the city of Toronto had, this is right at the very beginning of COVID, the city of Toronto had, as it turned out, a virtual conference taking place. It was always planned to be virtual, and the mayor spoke at it. And there were all these developers. It was the tech industry in any event who was meeting there. And these developers were told by the mayor, hey, there's lots that we can be doing with technology. In fact, what we're going to do is I've asked if we can use cell phone location data from the telecoms, the big telecoms, Rogers, Telus, whomever it was. He never said which one it was that he spoke to, in a bid to slow the spread of COVID-19. He said, maybe we can have heat maps taken down. So we'll just access this cell phone data from the telecom companies, and we'll be able to track the disease. And the Logic got on the phone with me at 10 o'clock at night. I gave a comment, and then I ended up talking to John Tory later that night. He's that kind of mayor that he will sometimes, if you send him an email you back or call you back. And he said, come on, what privacy rights are there? So I gave a pitch as to what the problem was. And he went off and he talked to his general counsel. And sure enough, he said, oh, yeah, you're right. The problem is I thought the heat map would be telling us where the COVID disease is, but really it's just telling us where people are. And we don't know that those people have the disease. So he got it. The mayor got it. This is where the category error arises in the context of privacy and surveillance. Okay, are we searching, seizing, or surveilling the virus? Well, that's no problem. The virus doesn't have any rights. It doesn't. How would we track the virus? I mean, other than testing a human being, maybe there's some question as to whether or not dogs can smell the virus. Although I believe that, in fact, they're smelling someone who's symptomatic, but maybe not. But imagine that you could teach an animal to smell the virus. There would be some privacy implications because they'd be smelling me, just like a dog would be smelling somebody to determine whether or not there's the presence of drugs. We have to talk about the extent to which that might be a violation of privacy. But for these purposes, if you're just tracking the virus, and if you had a way of tracking the virus, that's fine because the virus doesn't have any rights. Or are you trying to surveil a person without the virus? Well, clearly that is not the point of all this. We're not trying to track people. We don't care about those who don't have the virus. Arguably, I'm not saying we don't care about them. I'm saying if we're trying to track down the virus and we know somebody doesn't have the virus, we don't need to surveil that person. So then really what we're looking to do is surveil people with the virus. And we do that through contact tracing, through that nose tickle, through symptom queries. If you had fever, if you come in from another country, use the temperature gun, and maybe, to use the John Tory idea, a heat map. But again, that presumes that these are people with the virus. So is there a way for us to distinguish between people who have the virus and don't have the virus other than through these tests that I just mentioned here? The symptom query, the temperature gun. Still, we don't know that they have the virus. All we know is that they are at a greater risk of having the virus, but we don't know that they have it. Under our Constitution, a reasonable limit on my freedom is going to arise only when the limit is, remember, prescribed by law, not spoken from the podium, but prescribed by law, and it needs to be necessary and proportionate. So is it proportionate to target everybody who might have the virus? The answer is no. That's always going to be disproportionate. So it's got to be, is it necessary? Yes, it's necessary. Is it proportionate? Is there another way to determine who has the virus other than that? Is there a way for us to be proportionate? And the answer is yes, there's always a way to be a little more proportionate. The question is whether or not it ends up being reasonable. My point being that there's a big difference between surveilling a disease on the one hand and surveilling the possibly diseased on the other hand. One of them is constitutional, clearly. The other one, it depends. It depends. Do we know they're diseased or not? So that's why the quarantine, and I'm enunciating these principles to get at the problems, but they can be applied to any aspect of our civil liberties during COVID. So the quarantine rules. If somebody's been in another country for a period of time and traveled, there's a presumption that they are necessarily a higher risk coming into this country, necessarily a higher risk. And so they're quarantined. Some countries don't let anybody in, but in the case of Canada and the United States, yeah, you can come in from the United States, but you need to be quarantined. There was a time when Americans weren't allowed in, but there's a time in which they have been allowed in as long as they quarantine. So the argument is that there's evidence, demonstrably justified. There's evidence that in fact, this person is high risk. They're coming in from out of the country. And it's proportionate because we're not putting them in jail. We're telling them that they have to go home and stay home. And then there's a number of exceptions provided for the quarantine rules, federal quarantine rules. And those exceptions are where the proportionality is to be found. Similarly, all of the rules, social distancing, masking, but then you might remember in the spring, the rules around you can go through a park, but you can't be in a park. Remember that? You can be on a park bench. No, you can't be on a park bench in Toronto. Oh, yes, you can be on a park bench if you're resting and a senior. But if you're recreating on the park bench, then you can't. This was an instance where there were too many rules, there were too many laws, and a number of them were not proportionate. In an effort to modify the behavior of the virus, governments were modifying people's behavior, whether they had the virus or not. Again, the error was the assumption that behavioral modification equaled disease modification. It didn't. Behavioral modification may or may not have reduced the risk of transferring the disease, but we wouldn't know if that person getting the ticket for sitting on the park bench, in fact, had the disease. If somebody has the disease and they knowingly give it to somebody else, if somebody has COVID and they knowingly give it to somebody else, that's a criminal offense. It's akin to assault, probably aggravated assault, or maybe criminal negligence if the person is seriously harmed or dies as a result. We've already got rules for that. If you knowingly try to harm somebody. But if you're walking through a park and you get a ticket because the bylaw officer is not willing to exercise or has the capacity to exercise discretion, and layered on top of that, all the biases that tend to be involved in all law enforcement come into play: racial profiling, implicit bias. Then you have a civil liberties disaster. So we had in Central and Eastern Canada $10 million in fines distributed, and no evidence that in fact it helped lower the curve. In Western Canada, they did not have this proliferation of rules. There was advocacy, but little in the way of enforcement. But it's not that in BC in particular, but same with Alberta, Saskatchewan, and Manitoba to a certain extent. It's not like it was worse there. So you could say they didn't go hard on enforcing behavioral modification. They went hard on public education. Now, I'm not saying that that's why Western Canada has had lower COVID rates. I'm not saying that the public education, no enforcement approach, in fact, is going to improve a jurisdiction. But you certainly can't argue that the tough enforcement approach in Central and Eastern Canada created a situation where there was less COVID than in Western Canada. In fact, it's the opposite. Lastly, and I know we want to save time for questions, I want to say something about the contact tracing app. So thanks to the Israel Democracy Institute, we can see the different models of contact tracing apps that have been created in different jurisdictions. China, the least civil liberties respecting organization from the Freedom House Democracy Index. They're in the 0 to 80 category. You can see at the bottom of your screen the index. In fact, their surveillance method was facial recognition and social scoring. So people had a score attached to their biometric fingerprint of their face. And on that basis, as that biometric fingerprint was surveyed everywhere it went, including the use of an app on the phone, they had central mandatory mass surveillance. And there is an argument to be made that they were more successful at containing the virus, although I don't think we're going to be able to say that right now. We don't have all the information in terms of what actually happened in China, but that's the nature of that country. Israel, central mandatory mass surveillance as well, all GPS based. It's run by the Secret Service. It's not run by public health authorities, although it is supervised by Parliament and the Supreme Court. I'm not going to go through all of them. At the other end of the spectrum, UK, Germany, Switzerland, Austria, and Italy, and Canada falls into this category. A voluntary app and a decentralized model, and it's Bluetooth based. And the long and short of it is, as you may know, you voluntarily download the app. You don't have to. For city employees, provincial employees, but not federal employees, the app is pushed onto their phone, but they actually don't have to use it, the employees. You can imagine a scenario where they would be forced to, or required as one of the terms of their employment, to download it and to use it. And that's going to create a constitutional problem. Let's not talk about it right now. Let's just talk about how it works right now. So I have it, I use it, this app, I download it, I turn it on, and if I haven't yet, but if my phone gets near somebody else's phone, who has indicated that they tested positive for COVID, then I know not that I have the disease if it alerts me that I've had contact with someone. It just means my phone has been near someone who is tested positive. That doesn't mean I have it. And again, that's the difference between the risk that I have it versus not having it. It's then suggested to me, but it's not required of me that I go and get tested. It's then suggested of me, but not required of me, that in fact, I test positive. I then tell the app that I'm positive, and then it tells everybody else. The last issue, and I'm going to stop other than to say that it's an issue, is with respect to mobility rights. Newfoundland and Labrador, PEI, New Brunswick, and Nova Scotia all have a measure of mobility right restrictions, and they're called travel bans. And if you're watching this in Ontario, you can't go into these provinces unless you are a resident of these provinces. So if you're a student at York, for example, and you're living on campus, you're not a resident of these provinces. You can't go to these provinces. In Canada, under Section 6 of the Charter, we have mobility rights, which the Newfoundland Superior Court has ruled means that the province can't stop you from coming into the province. That's a violation of Section 6. However, the court said it was a reasonable violation of Section 6 under Section 1. I'm not going to get into that. That's being appealed right now. The other provinces are doing it in one fashion or another. And this is a problem partly about category errors, but also about our country and our confederation. And this is the extreme result of decentralized emergency management in Canada, is that at a certain point, a Berlin Wall is thrown up, and people on one side of the wall are not allowed in to the other side of the wall. And the problem with that is that it's all within the same country. In the United States, none of this is going on. None of it's happening. You can't be stopped from going from Arkansas to Mississippi to Tennessee. You can't be stopped from going to those states. And nobody's even suggested that that could be a possibility. You could be stopped from going into the country, sovereign borders being controlled. But within the country, our argument is the provinces don't have the power to stop Canadians from going into their provinces. So again, in closing, thank you for this. Please go up onto our website, ccla.org, and follow us on social media, and get onto our mailing list so you get updates from us. And if you want an opportunity for a rebuttal or to follow up further on what I've said, there's my email address. Just connect. Thank you very much. And I'm now very happy to take people's questions. Thank you, Valerie. I see you're clapping there. I'm grateful for that. I saw this going on. Thank you.
Perhaps I could suggest that if you'd like to ask a question, you could raise your blue hand.
Oh, I see a blue hand. Oh, I saw it go up and go down. Wait, no, there it is.
Turjoy. So Turjoy, go ahead.
Sure thing. There's also a question in the chat as well I just want to mention. So right after Mike, you guys can move on.
Thank you.
So as I was kind of listening to this talk, I feel like one of the issues that I seem to have with this lecture is, at what point do civil liberties kind of come in, and the government's will or the need to kind of protect the populace from this pandemic also matter? And from the lecture that I've heard so far, it seems to be that the government's kind of doing a lot of things that is kind of overstepping their hands. But at the same time, I recognize that, this is definitely something that's new, like as in they're handling a pandemic and the illegal intricacies with it for the first time realistically?
Okay, great question. Philip McEwen also in the chat asked, I think, a similar question in dealing with, and he wrote, in dealing with COVID by legislation rather than podiums, is that practical in such a volatile situation? Similar question. Okay, so our Constitution sets out the parameters around the exercise of powers by people in authority. We can't operate outside of our Constitution, or else it's that someone's operating unlawfully. And, you know, the conflict arises where a wrong has taken place. So let's say somebody gets ticketed because they didn't follow the instructions provided at the podium, but they did comply with the law. And they're supposed to pay this fine. They go to court and hopefully the court rules, yeah, well, they didn't, you can't show me the law that they violated. What somebody says isn't the law. They don't have that authority. And the reason we don't just say the premier or the health minister has the power to set the laws is because that would concentrate too much power in a single person, number one. And number two, you wouldn't be a democracy. You would have a despotic system where somebody was using their power as a personal exercise of their personality, as opposed to something that they'd been authorized to do. To manage a pandemic, the first thing that a government needs is legislation before the pandemic started that gives them the powers that they need. And in the SARS Commission report, which is online, and like I said, authored by Archie Campbell, he encourages and spends a volume talking about how this is an urgent matter that needs to be done in the 1990s, the early aughts. And it happened in the early aughts in Ontario. And it happened to happen while I was in the government. So I remember when our emergency management legislation came through. And what happened was, as the Attorney General, I was there to try and uphold the rule of law and avoid the government passing unconstitutional laws. So I was kind of playing the role that I play now, unusually, perhaps. But I was playing the role I play now, in that my job and the ministry's job is to be the voice of civil liberties of the Constitution. That's always how it's supposed to work. And to a certain degree, that is how it works. But certainly for this legislation, it did, because it was affecting. So we had the time to negotiate and debate and then eventually decide what the rules and the laws were. You don't have that. You don't have that ability to do that during the pandemic. So in the early part of the pandemic, those provinces and territories that had emergency management laws, and most of them did, gave them the powers to, for example, pass the orders in council that I mentioned. So in terms of expecting, say, an order in council or a law to be passed in advance or instead of the premier getting up and deciding here are the new rules, just think about what goes into one and what goes into the other. What goes into whatever the premier or the health minister is going to say at the podium, it's not done on the fly in the sense that the person's making it up at the podium there. And if they are, you can imagine, you would rightly say to yourself, well, that doesn't make any sense. How can we rely upon something that is just a whim? And you can't. That would be contrary to the rule of law, it'd be contrary to our Constitution. It wouldn't be very good governance. So what happens is every time you have one of these podium presentations by a first minister or a health minister, there's a communications package that also goes out. And on the website, there'll be some new messages and new graphics. there's work done, in other words, to get it to the point where it's presentable. Typically, let's say, done by the Premier's office. If they take that work and put it into legal language, and there's lots of people in the ministries of Attorney General across the country who do that for a living, and they're good at it, and they can do it pretty quickly. By pretty quickly, I mean as quickly as a communications person can write out the communications package. They then have to go and get a few people to sign off on it. In some cases, it's only going to be 5 people. But what happens is, I can say from experience, sometimes someone will say, whoa, wait a minute, actually, have you thought through this or have you thought through that? And you not only spare the people the possibility of being faced with a law that's unjust, you also save the government from itself. I always thought the job of the Attorney General is to save a government from itself. And you certainly save yourself from doing something that's going to be struck down by the courts later on. So it's not any more effort to do it by law than it is to announce what the law is. Secondly, if you wanted to, you could create this power that in essence, the government, which again could just be 5 cabinet ministers, the government has the power to make it up as they go along. Now, I'm not sure that would pass constitutional scrutiny, but you could do it. And then you would have accountability for it. And in the next election, people would say, do I want to have a premier who ran a government that gave itself the power to make it up as they went along? And democracy would answer that question. So it's not so much about the dynamics of a pandemic that's at issue. The question is, what is there already to manage that? And if there isn't something, then you got to go get it in order to have the legal authority to do it. And if you don't do it, then that's the difference between a country based on order and a country based on chaos. I see another question from Greg Levine on the chat. The beginning of the pandemic period, a lot of municipalities in rural Ontario tried to stop people from coming from the cities to their municipalities, and they did it in a bunch of different ways. And the question is, well, I'm going to ask the question, was it lawful? The answer is no, it wasn't lawful. The OPP was stopping some people. It was either on the 400 or Highway 10 and telling them to turn back. This was the police exercising their authority unlawfully. They had no power. There was nothing in the Police Act. There was nothing in any legislation that said that you're allowed to tell people to turn around and go back south. There was no rule in place with respect to mobility rights in small towns versus larger towns. It was driven entirely by fear. None of it was demonstrably justified, and none of it was prescribed by law. The challenge is, how do you challenge that? So we at CCLI could say this, it's not lawful, but the only way to get the courts to challenge it is you needed somebody who, for example, got a ticket for doing that. Sometimes the civil courts can provide remedies too. And I think that there is some class actions taking place by landowners against municipalities for those who bought cottages and were paying taxes and were denied entry into the towns. And that's the remedy for that. But that's another example of mobility rights run amok.
I think we have a question from Tristan.
I think over the past couple of minutes, the questions that I did have been spoken to, so it's okay. But
Thanks, Tristan.
Okay, I think we also have a hand up again from Turjoy.
Yeah, I just wanted to kind of do a follow-up question based on your response. From what I understand, it's that government or state officials need to have planned in advance the legal, I guess, the legal powers that they can have during such a crisis. And so, if that is the case, then the question I want to ask is, to what extent can they predict what kind of legal powers that they'll need for such a case? And when, and if they do kind of draft something along those lines, then how can they be sure that those powers in themselves don't become too much in trying to govern the populace, right? And then I guess the example could be, maybe they could, for the next pandemic, based on this one, they could say, we'll give ourselves future powers to mandate that everyone has to wear a mask. And the question is, well, would that be too much? I mean,
yeah, great question. And it is the nature of emergency management that the laws of today are drafted with an eye to the rearview mirror. So with SARS, when SARS happened, the provinces did not have really any legal powers to do anything. And they didn't even have the power of quarantine. They would tell people, please quarantine, but they had no legal ability to keep them quarantined. So what happens is that an effort is made with the legislation to anticipate what will be needed without going so far and to make it so general that it will, in essence, authorize what I'm going to say is despotic behavior. It's going to authorize something that the legislature wouldn't authorize. So, for example, if you had passed a law prior to COVID-19 saying that by order in council, the province can order that everybody has to wear masks, I think that provision would never have passed, because I think prior to 2020, I think people would have been really alarmed by a requirement that one has to wear a mask. And it was only when we were in it that we could come to see the necessity. Although even then, some people object to it. Now, the Canadian Civil Liberties Association's view on masks, for example, is that it is such a de minimis violation of our liberty. It's not a big deal for me to put on a mask. It's just not. It's not like somebody taking my personal identity. It's not like being handcuffed or seized. The limitation is a little hard to breathe, can't hear, I look different, you can't see the expression on my face, and that's it. This is not a serious violation of our liberties. It is necessary and it's proportionate. But didn't exist. We didn't know that it existed. So the question is, can you draft a provision that would cover the subject of communicable diseases and address matters of infection? And that's really the art and science of legislative drafting. And you give the power to the government to deal with, general issues with respect to the transmission of disease, airborne or otherwise. And then that gives the authority to the province to create the specific rule that then gets interpreted by other officials. But you're right, you can't know that masks are going to be required and necessary and proportionate in 2018, when in fact we found out that they are. So that's why during this particular pandemic, it became necessary for most provinces to go back to the legislature and give the government new powers that will allow them to better manage COVID. And while generally speaking, we're opposed to that, we think that they should manage it with legislation that it doesn't suffer from a wisdom deficit and a time deficit. That's our view. A majority of the legislature disagreed with us, and the quality of the legislation, time will tell.
Okay, thank you so much.
Thank you.
I wonder if there are any other questions. We did start a little bit later. I know it's Philip. Would you like to ask your question?
Like technology and its effects, is the law always a step behind pandemics? And if so,
Right.
back to my original question.
Yeah. No, not necessarily. Just take Ontario. Ontario had the legislation that allowed them to do everything that they were doing by order in council. And they did end up going back to the legislature, I guess, late spring, early summer, but it did them fine for months. The technology, even more so a problem. But again, arguably, you can use the existing laws to apply to technology that wasn't envisioned at the time that the law was passed. But that's an acute problem in Canada because unlike European Union jurisdictions and unlike many states in the United States and other jurisdictions across the globe, we don't have modern data privacy, modern technology regulation. And besides the fact that the industry has been unregulated for over 20 years, from a trade perspective and a securities perspective to a certain extent, from a privacy perspective, they've been entirely unregulated in Canada. So a lot of the really the things that we would find offensive at CCLA, they're offensive to principles of privacy, but they are lawful. So the example of the Cadillac Fairview facial recognition technology being used on people, I can make an argument that it was unlawful. They can make an argument that it was lawful, that there in fact was nothing on the books that anticipated this. So you're right that in fact technology and its effects is often ahead of the law, it seems. But that depends on how the law is drafted and whether or not the law gives powers to cabinet, to the executive branch, to pass order and councils to deal with these with such matters as changing technology. Because a cabinet meeting can happen. We've been talking for almost an hour. You can get a lot of order and councils passed in an hour. A lot. I'm not saying it might take an hour to draft one, but there's a lot of people who work in government who can get orders in council done up. And if you look at the orders in council being passed by many provinces, if you can find them, then you will. One of my complaints about the rule of law and the use of orders in council and the use of the podium is the unknown. There might be an order in council that, in fact, authorized the first minister to say what he or she is saying at the podium. But finding it, the transparency and accessibility is not there. The federal government has done a good job at, in a timely fashion, posting these orders in council when they pass, but the other provinces have not. So I could give examples, but I don't want to get into that. I just want to give Philip McEwen an opportunity to do a follow-up if I didn't answer his question.
No, Michael, you've answered my question quite well.
Okay, good.
Michael, I wonder if I could ask a question and abuse my rights as a moderator here. Is the Canadian Civil Liberties Association getting a lot of inquiries regarding infringements of either their privacy or any other rights during this pandemic? And are you sponsoring or filing any cases in the courts at present regarding these issues?
Yes, we have on our site the ability to collect information from people who feel that they've been ticketed or somehow wronged. And we're gathering that evidence. It's, the extent to which at a certain point we have a big enough sample size that we can rely upon that research and it finds its way into our reports. In some cases, the people will leave their contact information and we'll be able to reach out to them and follow up. So that happened with a couple of cases. And in those cases, we agreed to intervene if it does go to court. With respect to, or they'll just email or call us, or they'll say something and we'll see it in the media being covered, or the reporter will call us about it. And that's how we ended up filing our case in Newfoundland and Labrador. We had somebody who said, I consider myself a Newfoundlander, but I live in Halifax, Nova Scotia. My mom passed away. I wanted to go to my mom's funeral and I was stopped from going to Newfoundland. And so we started an application with her. We were the public interest organization, and brought it to the Superior Court, and we're now going to the Court of Appeal with it. We may go to the Supreme Court of Canada. It's the first mobility rights case of its kind. Up until now, mobility rights have been focused on trade and, selling and vineyards, like, can I sell my Ontario wine in BC, those issues. But this is obviously quite different. So we're there on that. We're in Quebec on Bill 21, which isn't a COVID issue, although it has COVID impacts it. Bill 21 is the law that restricts or forbids people who are in public service wearing a religious symbol. So maybe a face covering, hijab or a burqa or a kippah or a crucifix or a turban. You can't wear them if you're a teacher, for example. So the face covering as a symbol of othering, as I think Tony Blair put it, unfortunately, has completely different implications during COVID, of course. We're all covering our faces during COVID. And that hearing is taking place right now as we speak. We have brought, along with a coalition, an action against the City of Toronto with respect to the conditions within shelters, and succeeded in getting the city to change its policy with a decision from Lauren Sawson, former dean at Osgoode Hall of York University. And also brought a matter before the federal court involving federal prisons, same issue, social distancing, unhealthy conditions in the federal prisons. The provincial corrections in Ontario, on the other hand, really set the standard for the whole country, I should say, to their credit, to the Ontario government's credit. Best kept secret during the pandemic is a third of our prison population was freed. 1/3. It's incredible. It's an incredible number of people, not awaiting trial, convicted, in jail, serving out their sentence. 1/3 of them were freed. Ankle bracelets were purchased and they're monitored. Obviously, there's liberty implications on wearing ankle bracelets, but you got more liberty with an ankle bracelet outside than anything inside jail. And it's not like we've had a crime spike in Ontario as a result of all those people being freed. And in Alberta, we're intervening on the case that allowed where the legislature gave to the executive, the cabinet, the power to, in essence, pass legislation. So they gave themselves the power to make up new laws. Now, we've argued that's unconstitutional, but one of our previous questions was, how are you going to adapt? Well, the Ontario legislature said, we're going to adapt. We're going to let the government do whatever they want, and we're going to give them the power to do that. And they did it. And we may have to, unfortunately, go to court in New Brunswick. Oh, sorry, we're also in New Brunswick it's not really a COVID matter, although the abortion clinics were shut down in New Brunswick around the time that COVID broke, although it was something that had started under the Hague's government. And now we are challenging New Brunswick lack of access to abortion, and may also, that's happening, that's been filed. And the last one is there's a bridge between New Brunswick and Quebec. First Nation children on the Quebec side, 20 of them attended a high school on the New Brunswick side. The teachers on the First Nation in Quebec can come to teach the class in the empty classrooms, but the students cannot. This is a violation of mobility rights, and one could certainly argue that it's also discrimination on the basis of their being Indigenous. That one, I just thought that would be fixed. I thought once the government became aware of it, that it would be fixed. And when we came to assess what the law is, the law actually that they passed during COVID, the law that they passed during COVID authorizes the First Nation kids to attend the school. The Deputy Minister of Education called up the chief and said they're not allowed to come to school. So before we had a question about, everything's happening too fast, why would we give? Well, there's an example, because that deputy minister is exercising their authority without any lawful authority to do so. The law says let him in. The deputy minister says don't let him in. And so actually we're just trying to get the law to be observed, so we may have to be there as well. Those are the cases. We're also we were involved in the development of the COVID app. Informally, there were consultations by the government, which was positive. We expressed no concerns with respect to the Canadian COVID app. So I think that's the latest.
Well, we're well over our time. Michael, thank you so much for being with us here today and for your very informative and insightful presentation about the emergency management and the impact of COVID in terms of people's civil liberties. I just like to say, keep up the great work. You're an outstanding organization, and it's wonderful to have you as the head of that organization and keeping up the wonderful tradition in terms of protecting people's human rights. We certainly hope that you'll be with us again sometime in the future. So please join me in thanking Michael Bryant for being with us here today.
Thank you. Thank you very much. I don't know if you've got a law of pandemics class somewhere in one of your faculties, but count me in if you're looking for a new adjunct. I would love to do that. Thank you for inviting me. It's been an honor to be here. Thanks for your excellent questions, everybody, and have a great day.
Thank you. And we will pass on that information about the COVID class and civil liberties. Thank you.
Yep. Bye-bye.
Bye, everyone.
Bye.